and patents and design filing. We are conducting this workshop in collaboration with Rajiv Gandhi National Institution of Intellectual Property Management, Government of India, Nagpur. We always start any seminar, conference or workshop with a college prayer. In remembrance of Almighty, let us start today's workshop with college Shabad, Dev Siva Barmohe Hai, Shubh Karmante, Kabhu Na Daru. Is my PPT visible, sir?
No.
You can continue with our PPT, sir.
Yes.
Dr. G.H.G.
Yes. Visible,
For saving time, you can proceed, please. Yes, it is visible, sir. It is not visible. The screen is visible.
वाहिगुरु जी का खालसा वाहिगुरु जी की फतेह देह सिवावर है सुख कर मन ते कब ना डरो सुख कर मन ते कब ना डरो अर तो जब जाए लरो निश्चय करे अपनी जीत करो निश्चय करे अपनी जीत करो बोले सोनिहार सती अकाल देह सिवावर मोहे है सुख कर्मन ते कब ना डरो शुभ कर्मन ते कब ना डरो अर सिख हो अपने ही मन को लालच हो गुण ताचरो लालच हो गुण ताचरो बोले देह सिवा पर मोहे है शुभ कर्मन ते कब ना डरो शुभ कर्मन ते कब ना डरो जब आव की औद निदान बने अत हिरण ने तब जूझ मरो अत हिरण ने तब जूझ मरो बोले सोनिहार सती अकाल देह सिवा पर मोहे है शुभ कर्मन ते कब ना डरो शुभ कर्मन ते कब ना डरो शुभ कर्मन ते कब ना डरो वाहिगुरु जी का खालसा वाहिगुरु जी की फतेह Intellectual property rights refer to the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. These legal rights have give out an exclusive right to the inventor or creator to fully utilize his invention or creation for a given period of time. So, to talk about this topic in detail, we have eminent speaker with us, Dr. Bharat N. Suryavanshi. He is Assistant Controller of Patent and Design, Nagpur. Dr. Bharat and Suryavanshi is working for more than 18 years in central government office under the Patent Office, Ministry of Commerce and Industry, and presently working as Assistant Controller of Patents and Design. He has done PhD on the topic bioefficacy and phytochemical studies on medicinal plants of Kinvat and Mahur forest of Naded district from Swami Raman and Tirath Marathwada University, Naded, Maharashtra. He has done MPhil and post-graduation in biotechnology from Gulbarga University, Karnataka. He has published various national and international papers. He has delivered many lectures on IPR in various parts of the country. He has deputed for training at Tokyo, Japan on examination and IPR issues. He has given landmark decision by rejecting Pfizer patent application for artistic drug which was filed in India in 2015. So, on behalf of GHG Governing Council, Principal of the institution, Dr. Pargat Singh Garcha, all faculty members and students, we welcome you, sir. Now, Dr. Bharat and Suryavanshi will speak on intellectual property rights and patents. Dr. Bharat.
Thank you, sir. Thank you so much for your introduction. I also welcome you all for the IPR session on behalf of Rajiv Gandhi, National Institute of Intellectual Property Management, Nagpur. I'll start with my sharing the slides. Are you able to see my screen? Anyone, please?
Yes, sir.
The slides are moving.
Yes, sir. Fine.
Okay. Now, first of all, I say that our office is called as Office of the Control General of Patents, Designs, Trademark, and Geographical Indications. We are having different locations. Patent and design offices are at Kolkata, New Delhi, Mumbai, and Chennai. We are having PIS, that is called Patent Information System. Now it is called as Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. We are having trademark office in addition to 4. One is at Ahmedabad and geographical indication office at Chennai. These are the pictorial view of our offices: Mumbai, Delhi, Chennai, and Kolkata. You might have visited Delhi office for filing of patents and design applications. This is our training center wherein we give trainings to all professors, IP officials, students, researchers, scientists, even for the foreigners who are coming in the WIPO and BRICS program for studying about the Indian Patent Act. This is our website. If you want to know details about that, you can click on www.ipindia.gov.in. You will get all details about the different kind of intellectual property. This is an awareness program. I cannot go in detail on each IP. If I want to study patent, it takes years together to be perfect. Therefore, we are conducting many more programs every month, every week in our organization. So we are keeping updates on our website as well as on a social media account like Facebook and Twitter. Please make a note of that. If you want to join, you can join and take the benefit of that. Let us see today's topic, that is intellectual property. By seeing my slides, you might have thinking something which is product of mind is called intellectual property. Yes, to make you aware, I made the slide in this fashion to know you about that. How it arises? During discussion in the classroom, if you are taking the class, or you're doing the research, if you are in the lab, or sitting in group or in alone, thinking on some problems and giving solution for that. Therefore, intellectual property can be said that the property which arises from human intellect or it's a product of human creation. For example, today you are sitting at your college and thinking that today we are enjoying the petrol, diesel roaming around or in India with the four-wheelers, two-wheelers. So somebody among you is thinking that how we can prevent the further problems in the next generation. So you have to produce biodiesel. Somebody developed the process of preparation of biodiesel from so and so plants. That's an intellectual property. You are thinking and giving solution for that. If you are developing a device which convert solar energy into electrical energy, that's again thinking how we can give convert solar energy into electrical energy. So something which is product of mind is called intellectual property. I'll quote another example to make you more understand about the intellectual property. In December 2019, we heard about the coronavirus. We don't know before that what is coronavirus, what is molecular constitution, what is morphology also. But when came in December 2019, the news spread all over the world. Scientists started to do research on that because we are not having any treatment method nor vaccine for that. So scientists thought and they carried out the research on that. And in the middle of 2020, we got Covaxin, Covishield, Sputnik. What is this? This is an intellectual property arises from human intellect when he thought on that problem. Therefore, we can say intellectual property means the property which are a product which arises from the human creation. Human is an intelligent animal in the animal kingdom, so he is having power of thinking, so he can give solution to any kind of problem. The solution may be in the form of product, process, design, or mark also. Something which creation of human mind is called intellectual property. Let us see what is the background of intellectual property. Property means our mind goes to the tangible form of property. You say, I am having car, gold, plot, flat, so I'm rich enough. But there is another kind of intellectual property called as intangible form of property. That is intellectual property. In this, we are having industrial property and copyright. Industrial property includes patents, designs, trademarks, and geographical indications. Let us see what is the definition of intellectual property. How we can define. It's a intangible creations of whom? Human intellect, having commercial value, asset like any other form of property. It means intellectual property is having commercial value like other property. Other property means what? Gold, flat, which you are having at Noida, or any construct a new house. If you sell it, or if you are on the rent, if you are giving, you earn something out of that. Same way, if you are also developing intellectual property like drug, medicine, composition, you can license to anyone with the royalty, and then you can earn out of that. Therefore, it's an asset like any other form of property. There are different intellectual property rights. Patent is called as an exclusive right. For example, one of the professor from your college or a student from your college is getting patent on herbal composition for treatment of dandruff, then definitely the rights he can exercise, he can sell it, he can produce it, or he can give license to anyone, but not his nor his teacher, nor his brother, sister can exercise the power of that. Therefore, IP is also called as a negative right because other person may not exercise any kind of power on that registered patent. Again, patent is an territorial right. If you are applying patent in India for your dandruff composition, it's valid only in India. If you want to stop the person from other country, or you want to establish your right in other countries like USA, Japan, Germany, or any other country, you are supposed to file the application in those country also. Then only you are getting the right, and you can stop them from the using or selling your dandruff composition. So, how we can file? By means of PCT, that is called Patent Cooperation Treaty, or by means of conventional application as per section 135 of the Patent Act. Again, IP is an licensable right. If you are getting patent for the technology, design for any kind of product, or mark for the any company, then it can be licensed to anyone whom you want, and you can get the royalty out of that. 1 minute. डब्बा दिखा एकदम भारी सा लागलास आणि मोठा डब्यात राहायचा आहे नंतर कार्ड पण तिथे आहे. So you can license to anyone whom you want. Let us see what is the definition of patent. CNG पे टाक. Exclusive monopoly privilege are rights granted by the government to the patentee for 20 years from the date of filing or priority for commercial gain in concession of the full disclosure of his invention as a territorial right not ordered. So patent is giving for 20 years. When you're disclosing everything, many professors or common man comes to us, they say, I have developed a process of preparation of an herbal composition or process of preparation of some medicine. But there are 2 or 3 are very crucial steps I don't want to disclose with you. But to meet the requirement of section 10(4) of the Patent Act, you have to disclose everything with the examples. Then only Government of India is giving you right. Otherwise, no. You will get an objection from the patent office that your application is not fully, particularly describing the invention. Still, many are in confusion with what is discovery and invention. Discovery means finding or exploring something which is already existed, and discovery as such has no technical effect. For example, if I'm isolating a microorganism from cement industry, jute industry, or effluents of some hospital, the process what I am employing to isolate that microorganism is new because I may change pH, temperature, media for the isolation. But the microorganism what I'm isolating, that is a discovery, because we know that effluent of industries are having microbes. So I'm isolating. That may be alcoholophilic, acidophilic, or any kind of bacteria. But genetically, if you are modifying that microorganism by using genetic engineering technology, that's again patentable subject matter like oil eating bacteria. Therefore, we should know whether you are doing research or inventions or discoveries. If it is invention, please go for the patent filing in India. Let us see what is invention then. When we can say the project what you are doing is a new, fulfilling the requirement of invention, or the PhD thesis what you are writing is qualifying for the invention, or the project of B.Pharm or M.Pharm students are doing, whether that is qualifying for the invention or not. To be an invention, it should be a new product or process. Product includes herbal composition for Parkinson's disease, a lotion for skin problems or psoriasis. Process means a process of preparation of herbal tea, a process of preparation of and some composition. Again, it should be useful. Again, novel and non-obvious, not public knowledge before the filing date. Even for the paper publication, we check whether it is new or not. Then only we are going for the publication in the international journal and national journals. But same way, to say an invention, it should fulfill this criteria. Then only you can get patent for that. Simple example is sharpener. Before 1822, there was no sharpener. First time C.A. Busher has given the technology in the market, and he has not given the word sharpener. He has used the word tool. Tool means a big machine in the engineering field. Therefore, he has written the claims like tool for sharpening a pencil, writing point by saving away its own surface. This is the way of writing the claims, because patent is an techno-legal document. Technology we have to describe in the legal format. Again, in the general knowledge, we have studied motor dabba. In general knowledge, we have studied the what is who has invented electric bulb, who has invented telephone, who has invented aeroplane, Many more we know in the general knowledge. So same way, first time those who invent, they are getting patent for that. Like Thomas Alva Edison for the electric bulb. This is the telephone invented by the Alexander Graham Bell. So can anyone among staff, student, professor, can you answer my question to make the session interactive? Why we have gone up to the mobile phone as the technology was existing in the 1876? Anyone? Why we have gone up to mobile phone? Because already telephone was there in the market in the public domain. What is the necessary for that? Are we are doing discoveries? Or is an invention? Please, anyone among professors, students, as though we are connected virtually, we can make the session as interactive. Oh, please, anyone? Hello, are you able to hear? Hello, may I audible to you all? Hello.
Yes, sir.
Yes, sir,
Yes.
you're audible. You're audible,
Okay,
sir.
you don't want to answer. That's all. Okay, I'll answer that question. See, this telephone is, if I want to dial you or connect my parents or connect my brother or sister, 10 times I have to dial. How much tedious it is? Again, I cannot change this telephone from my cabin to my principal's cabin or my colleague's cabin because it is connected at a particular point wherein connected connection is there. It cannot work outside of that connection. Therefore, to overcome these two disadvantages, the scientists of electronic and telecommunication started doing research and they came with the table phone wherein directly I can dial. But again, I cannot change from my cabin to principal's cabin or my colleague's cabin. To overcome that, again, they thought they came with the cordless phone, which is long. We can take in the hall, kitchen, and drawing room. But it cannot solve my problem. I want to take in the meeting. I want to take in my jab. So to overcome that, they came up with the mobile phone in India in and around 2000. When the mobile phone came, it was very costly, more than 5,000 simple Nokia device. Again, it is not having video calling facility. Now we got the video calling facility. Now you are sitting at Noida, I am here, but we are speaking to each other. What is this? Improvement of technology from 1876 to till today. So don't think that to get a patent, you should have something new. Even improvement in the technology is also patentable. Therefore, Nokia got patent, Samsung got patent, Apple got patent. In your field, like pharma and botany, I'll tell one example. For example, paracetamol is already in the market. If you consume today, if you're having fever today in the morning, it takes 6 to 8 hours to reduce your fever. But somebody comes with new herbal formulation by changing the ingredient of that, and that medicine cures your fever within 3 hours. It's an improvement. You can file the patent for that and you can get it also. Because you are solving some problems. You are showing efficacy of your medicine. Therefore, you are getting patent for that. Therefore, don't keep in mind that something you have to do new, then only you are getting the patent. Simple problems also, if you are solving, you are getting patent for that. Again, Bluetooth. Now you are saying, I'm having Bluetooth. I'll transfer the notes to you people, students, for your pictures, movies. Why? It was invented by someone else, not me and you. So something, if you are inventing, that's an invention. Nano car was not there earlier, but in middle we got, because that's an famous example of technology. Vaccines, example of technology. The Jaipur food, example of technology. Drones, smart calls. This device is an example of technology. This fellow, Ranganathan, since 20 years of his age, was working in the South India in his palm and coconut field. Every time he has to climb the tree very heighted to pluck the fruits, coconut and palms. So since on that day he was thinking, but in the middle of 50 years, he got an idea that he developed a 4-lock pin system. If you press on both the side, this side, his hand, directly he can climb the tree and pluck the fruit. So now this device is published. Everyone is asking for that and he's selling across South Asia. So simple problems, you are thinking and giving solution for that. That's an intellectual property. You can get patent for that. It's very simple device, but he can develop with a new idea. Most common mistakes by the inventors. You are people are doing research good, but you go for the publications before the filing the patent application. By knowingly or unknowingly, if you are publishing, please, within 1 year from the date of that publisher or disclosure in the conference, you can file the patent application. No worry, within 1 year. If you are having good inventions, maintain the secrecy in the public and file the patent application. Otherwise, somebody may copy and they file before you. If you are carrying your project or research, you are not sure that it's having value, then please complete your research, identify the value. If it's having value, then go for the patent filing. Otherwise, no. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, ornament, or composition of lines or color combination thereof. Apply to any article in the form of 2D, 3D, or both the form. I am having Milton water jug of this design. You might be having some other water jug with your in your cabin with your on a table. That design may be different. I am having comb. You are having also comb with different designs. I'll just show you. Your comb may be long, but my comb is round. This design is new. Any kind of design, if it is not in the public domain, you can go for the registration. Plus design, brush are of different design, car design, handle design, mere functional and technical feature of the article are not considered design. Term is 10 years. It can be extended for 5 years. Total term is 15 years. You can enjoy, means you can get the royalty for that. I'm using Dell computer. My computer design is different. You might having HP. I'm having Bajaj fan in my room. You might be having Crompton fan. I'm having LG fridge in my house. You might be having Whirlpool fridge. The design is different. Therefore, any kind of design, if it is new, that can be registrable. Design set of designs. It's called set of articles, which looks beautiful. Set of sofa set of chairs, spoons, knives of different designs. If it looks beautiful, that's an design. Sanitizing machine, the design is already registered. You are from pharma, you can check the different designs in the different products, like ampoules of white color and brown color is different because this design is different from this design. Syringe of this is different from syringe this. So each design is registrable. Capsule, this capsule is different from this capsule. So any kind of design you are in the pharma, you can go for the registration. In textile, curtain designs, bedsheet designs, jewelry designs is also different. I'm having Timex watch. You might have having Titan watch or any other kind of watch. You can check the design of that. You might having gold chain. That design is different, and my gold chain is design is different. So each design is different. If it is not in the public domain, you can go for the registration. Daily consumer products. My office bag is I'm putting backside. That is design is different, but this is keeping in hand. Difference. Briefcase design different. You can see water bottles of Aquafine, AquaGuard. Again, many bottles are there. You know the name of different bottles. The design is different. My wallet is this kind of design. Your wallet may be of different kind. This iron box design different from this. Pens are of different designs. Comb, as I shown you, is a brush. So any kind of design, you can go for the brush. Shape, surface pattern, ornament, bottles, that all the designs is different. Design of toy, school bus, bat, clock, biscuit, pencil is also different. You know Good Day, Parle-G, Monaco, but the design of this biscuit is totally different, which can attract the small children and facing of eyes, nose, and all. Therefore, it's a new design. You might have seen the pencils. Pencil, the peacock and parrot face is not there. So something design is different, which looks beautiful. You can go for the registration. This is the example of technology, that is patentable subject matter. Garrett Morgan, while passing on the road, he saw a terrible accident between horse carriage and a car. So he thought on that day, how I can prevent further accident. It was very terrible. What we do if somebody has accident, we'll give water to them, we put the hospital. We never think how it has happened. For example, I give During Ganpati festival or any festival, we bring many flowers, puja materials, leaves of banana, tulsi, many leaves we bring. After puja, we throw in the pond, river, or ocean. But you are being a pharmacist, being a technologist, being a biotechnologist, or any kind of student or professor, you never thought how I can prevent this pollution. How can I prevent this water pollution? If you would have thought, you would have given a biological treatment method for purification of water of pond, river, or something else. Because what government will do ultimately after completion of festival of Ganpati or any Durga Puja, they put chemicals in that and they clean that flowers and garbages. It affects the aquatic life of that pond, river, and to prevent that, if you would have given biological treatment method, that's an invention. So if you think, then only you'll get the idea. Garrett A. Morgan thought on that problem, therefore he got an idea. Another, I'll tell you an example for the patent. For example, you know the Parkinson's disease. There are many allopathic treatment, but many side effects too. So if you are thinking that if you are giving a herbal treatment for Parkinson's disease, that's a good invention. You can come in the form of wax composition, combining with some medicinal plants and some other experience with that. And definitely it's an palatable, easy to take also. This is an example of designs. See different designs. This design is different. This cookie is different. This design is different. Dress designs. Can anyone tell me how someone has got idea to with this to manufacture or make this design? Anyone? Until unless you think in your own field, if you are physics, chemistry, engineering, any kind of field, think the problems which are simple in your field you can give. For example, you are a medicinal chemist. There are many psoriasis for the people who are working in the field. If you are thinking a lotion or a herbal lotion for the treatment of psoriasis, you can study the medicinal plants which are useful for the treatment of psoriasis. You can come with the formulation, lotion, or anything else. Same way, somebody has thought that the people who are working in the construction company are having neurological disorders, back pain, this and that, because they are carrying stones, bricks, cement on their head, and it's causing problems. Therefore, he has developed this device which never touches to head, it is top of the head, and it never feel burden and they never suffer from the disease. So if you think on a particular problem, then only you are getting the idea of design, patent, or trademark. Therefore, think innovatively and come up with a new designs and patents. Definitely will be awarded. You can get the benefit of that. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the goods, to distinguish from the goods of the others, or it gives the authenticity of goods. For example, Tata, Bata, Reliance, all these are name and frame. It protects the innocent public from buying the goods of second-rate quality. For example, you know Pond's powder, which we apply. Spelling of Pond's powder is Ponds. If somebody comes in the market, POU, we never check what spelling is. We see the bottle size, color, we say it's pink, it means Ponds only, and we buy. That's second-rate quality. We know Adidas shoes and chappal in the market, in the mall, 4,000 to 8,000, but in Mumbai, roadside, in Bendi Bazaar, you can get in 200 because they're changing the spelling of that and coming with a second rate quality product, but we never check what exactly the mark is. We are buying that product. R with encircle is a registered trademark. TM is trademark applied yet to get the permission from the government of India. Duration is 10 years. It can be renewed every 10 years subject to uses like Tata, Bata, ICICI Bank, how they are long they are in the market. There are different trademarks like trade names, collective marks, certification marks, taglines, slogans like Google, Adidas, Dil Mange More, Naukri.com. This is an McDonald. Another kind of intellectual property called geographical indication. Place names used to identify the source of origin, quality, reputation, or other kinds of products like Darjeeling tea, Kanchipuram silk sari, Kolhapuri chappal, or the example of Jia, Rasgulla of Bengal and Odia, saffron of Kashmir, many more which in India. In filing of patents, designs, trademark, anyone in common in teacher, parents you can file. But in GI, group of people who involved in the manufacture of particular product having association in group, they can file the GI. These are Darjeeling tea, Makrana marble of Rajasthan, Ratlami seva of Madhya Pradesh, Kanchipuram silk sari, Katputli of Rajasthan, Bag prints of Madhya Pradesh, Bengali Patachitra. These are the examples of GI. Magai Pan, Devanalli Pomelo, Apimadi Mango, Kurg Oranges, all the examples for the GI. Let us see another kind of intellectual property called as copyright. Provides its holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is life of the author plus 60 years. Therefore, you might have seen the authors are no more for their books who were written, but they are getting the royalty for that. It's a bundle of rights. If you are writing books, novels, stories, you can go under section 2O for the literary work. Artistic under section 2C. Dramatic under 2H. Musical 2P. Sound recording, cinematics, depend upon that you can go. Now, how we can protect a single device with different intellectual property rights? For example, for example, you can take any example, but I have taken Sony TV in year around 2004 or in and around that. It's very famous for clarity and sound, especially with the two hoopers on the top of that TV. The remote control mechanism, we can sit on the sofa and we can operate the TV. That's a technology. So they got patent for that. How it looks beautiful with the color combination. So they got design registration. Sony name as such, they got trademark. The instruction which are there in the box of TV has got copyright. So single product they keep protected with everything. Therefore, another company who involved in the manufacture of production of TV never copies patent, design, trademark, copyright like Samsung. They never copy each other technology. They are independently playing in the market. If they're copying, Sony will sue them in the court. Therefore, they are having their own technology and they are in the market. So if you are also developing any device in your pharma or any instrument in the pharma or any process, try to get the patent, design, trademark if the IP is available for that product. Let us see another kind of intellectual property called trade secret. Trade secret is a technology which never been disclosed, maintained secretly years to year together. I have taken Domino's Pizza as an example to make you understand because everyone is fond of pizza. During my college life in the year 2000, we used to take poha, pakoda and all because cannot offer this. If a birthday party, poha in this. But now the college students for parties, pizza, cold drinks, Coca-Cola, this and that they are having. So they know the better taste of that. So if you have tested the pizza of Domino's or Pizza Hut and the pizza of other hotels and the pizza which prepared by your mom, sister or spouse, the taste is different because Domino's is adding some trade secret ingredient which are not known to us. Therefore, taste different. For example, the formula of Coca-Cola we don't know. They have maintained secretly. The formula of Mazda, the formula of Sprite, we don't know because they are maintaining as a trade secret. This example to again patent, design, trademark, all the mobile company have got their patent like Nokia, Samsung, Reliance, Oppo. Therefore, they never copy the technology of each other. Why we have to study the IPR? This is for the students. Why government is making us to know about the IPR? If you are a science graduate, I mean B Farm, M Farm, or any science graduate, you can become a patent agent. Every year, our office calls for the examination of the patent agent, examination of patent agent. Then you can apply. There are two papers. One is objective and the descriptive. If you qualify, you'll get a patent agent number from the government of India and you can practice. If you are a trade if you are a graduate, simple graduate or humanity graduate or commerce graduate or law graduate, you can become a trademark agent or copyright law agent. If you are having knowledge of IPR, you can work in the IPR policy, IPR cell in the central government, state government, school and colleges also. If you are having knowledge of IPR, you can the NGOs who are facilitating to file the patent, design, trademark application from inventor to the government of India. There are many IPR firms in Noida, Gurgaon, Delhi, Mumbai, many places you can work in that IPR firms. If you are MS in chemistry, biotechnology, microbiology, physics, or any branch of B, you can join to the government office, depend upon the advertisements and vacancies. There are again two papers. One is objective and descriptive. If you qualify, you will get job in the government of India. Thousands of scientists who are listening my lectures, faculties and students can also be inventor. Who is inventor? Who invents something new, who does something new in this field. How? By simple approach, but you are not doing. If you are carrying out a research fellow like MPhil, PhD fellow, if you are doing project like BPharm and MPharm fellow, identify some problems in and around your own field. Solve that problem, you can apply for the patent. As I have given you many examples, but again I'll try to give one example. For example, if you are an electronics engineer, many farmers still working in the field. They never sleep, they never take the rest. But if you are developing an alarm or SMS alert in the mobile when wild animals enter in the field, then it's a very easy solution for them because everyone is using mobile. They can get alert by knowing that. So if you give the solution like this, because already once water tank is full, we are getting bell. That invention is there, but why can't you do for the farmers? Or you can do biological mm, herbicides you can do, or pesticides you can prepare, or herbal composition for dandruff. You know, Vatika shampoo, clinic Doe shampoo, but if you bring herbal dandruff curing shampoo, that's a new invention. Or production of methanol, production of beverages from your campus waste, production of alcohol from food waste. So many are there, simple sort of inventions are there because you can do that, but you are not doing. What can be patented in India? In India, all the inventions which are product process are patentable in India, which are new, having inventive step and capable of industrial application. Section 3 and 4 relates to a non-patentable invention. You can check in the Patent Act. When we can say the research or the project what you are done is new or not. When it is, should not be available or published in India or elsewhere. It should not be in the prior public knowledge or prior public use within India, or it should not be claimed before in any specification in India or elsewhere. Then we can say the subject matter of your research is new. How we can say it's fulfilling the requirement of invention. Feature of invention that involves technical advancement as compared to the existing knowledge. I'll give you an example here. As I told you, paracetamol, which used to cure your fever within 8 hours, now it is 3 hours. That's a technical advancement. Or having economic significance. As I told you, mobile when came in year 2000, simple Nokia is of 5,000. Now 1,500, 2,000, 50,000 also. It's an economic significance. Or both. That makes invention not obvious to a person skill in that. What is obvious to a person skill in that? For example, if you are a common man, I am preparing a herbal tea comprising steps of taking cup of water, allowing it to boil, adding pinch of tea powder and sugar for that, and adding one of the taste ingredients, ginger. Another fellow from the Karnataka, if you preparing tea with the same process but adding as taste ingredients as an cardamom. Another fellow from Andhra, if he use or Marathwada, use the roots of some medicinal plants. These three are in the public. Cardamom, ginger, and roots of medicinal plants are in the public literature survey that they can add as an tea ingredient. The fellow from Punjab, by knowing these all papers in the literature survey are public knowledge, if he has visited all the three states and he tastes the tea, he can prepare the tea by using ginger, cardamom, or roots of some medicinal plants. Then it's very obvious to him to produce the tea. But to get the patent, it should not be obvious to a person. Like it should have an inventive skill. Then only you are getting the patent for that. Like surprising result you should get, or if you are giving solution to long-standing problems or fulfilled of a long patent. Like this, if you are doing, definitely you can get the patent for that. Again, it should be used in the industry or capable of being made in the industry. Now, how to file the patent application in India and who can file? Any person, national, foreigner, company, or small entity or startup, anyone can file the patent application at any age. You can file physically or you can file online, as we have given the facility since July 20, 2007. There are different jurisdictions. As you are from Noida, so your jurisdiction is New Delhi. It covers state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, National Capital Territory of Delhi, and the Union Territory of Chandigarh and Delhi. What are the requirements to file the patent application? Form 1, to know about the details about the applicant in that paragraph 9, to say as proof of right that inventor has to sign. If you are filing provisional, form 2 or complete also. Provisional means as soon as the idea comes to your mind, if you are filing, that is called provisional application. Complete means you are completing your research work with the claims. If you are filing, that's in form 2. Form 3 is required to state that how many countries in the foreign you are filing, what is the status of that application in those countries. Form 5 is to add your friend's name in the declaration of inventorship. In paper publication, we add our friend's name like first author, second author, third. Same way, if you want to add your friend's name, you can add, but keep in mind that in paper publication, they are not having equal right, but in patents, all the friends whose name you are adding as an inventor are getting equal right. So if you are developing any medicine and it has value, then you have to share your benefit to everyone. So think and add your friend's name. Until unless you request for Form 18, we never examine your application, you have to request. Fees in the form check or ready. If you are paying online, you can pay the fees online. These are the optional requirements if you want to publish early, Form 9. If you are choosing agent, you can file Form 26. Fees for individual is 1,600, for the others 8,000. You can check the fees on a website, the detail they have given. And also for the 80% fee concession for the all teaching institution. 4,000 for the natural person, 20 for the others in Form 18, that is request for examination. If you want to get patent early, that is called expedite examination as per Rule 24B. You can file Form 18A. When we can file? When you are choosing India as an PCT, that is Patent Cooperation Treaty, in that India as an international searching authority or international preliminary examination authority, then only you can choose for the expert examination. Or applicant is a startup, or as per the 19 rule, one of the applicant can be ladies in your group, then you can request for the expert examination. Or government organization or institute can also request for the expedite examination. Fees is 8,000 for the individual, 60,000 for the others. If you want forms, you can log on to www.ipindia forms. If you want to file online, ipindiaonline.gov.in. How we are giving the patent for you people if you are filing the patent? Once you are filing the patent application physically, it's go for the digitization. If you are filing online, we take it data as it is, and that is an, and we screen and classify depend upon the subject matter. Microbiology, biotechnology, chemistry, electrical electricity, we classify by using the International Patent Classification System, that's called IPC. Once we classify, then we take it for the publication. If you are requesting for early publication, as I told you, optional, then we publish it within a week or a month. Otherwise, it takes 18-month publication. Once it's published, anyone can file the pre-grant opposition by way of representation on different grounds given in the 25(1). Wrongly obtained, copy, all the grounds are there, you can check, and then you can oppose. If you are requested for the examination within 48 months on the date of filing, then you will give it for the allotment to the examiner and controller. Examiner carry out the search, he forward the report to the controller, controller again carry out the search, he amend, delete the objection, prepare the final report, that's called first examination report, FER. You have to reply within 6 months. If you are unable to reply, you can take extension of 3 months. Within 9 months, by hook or crook, you have to reply for that FER. If you are not replying, it will be deemed to be abandoned. If you are replying, we check again the reply file by you is okay or not. If it is okay, then it will go for the grant. If it is not okay, it will go for the refusal. If you are granting or rejecting, we give the speaking order. Once it's granted, then it can be published. That is called post grant publication. Then any interested person can oppose the case. Starting, anyone can oppose, but in post grant, only interested person can oppose the case. Now, who is the interested person? For example, Bharat Biotech of Hyderabad is developing Omicron virus composition. Then Biocon of Bengaluru, Serum Institute of Pune, or Sun Pharma of Mumbai can oppose because they are involved in the Production of same form of product, they are called as person interest. They can approach. Once the opposition grounds received from the opponent forward to the applicant, applicant will give reply on each ground to the controller. The reply we received will forward to the again opponent, opponent again give reply on that. If applicant and opponent anyone request on Form 7, then we give the hearing date. Simultaneously, we consider an opposition board inside the office. There are three officers, one is chairman, two are the member of that board. They give the recommendation on the opposition board. During the hearing, we consider this recommendation whether we have to grant or refuse. During the hearing, across the table like court hearing, we discuss each ground of the opponent with the applicant. If applicant overcomes all the grounds, we grant the patent. If applicant fails to overcome the ground, it will be rejected. If you are granting or rejecting, we give the speaking order so that you can appeal in the higher courts. What is the role of patent system? Encouragement or improvement of technology from X-ray machine to CT scan machine. We got the improvement. Providing reward as an exclusive right for disclosure. For doing the something, you are getting the right from the government of India. Making profit or earning royalty through putting the invention to practice. Don't keep patent for the namesake to get a promotion as a professor or principal. Let it work and get the benefit out of that. Transferring into public property after expiry of term, that is 20 years, or once patent is seized. What to do now? You came to know about the different kind of intellectual property like patent, design, trademark, GI, and geographical indication and trade secret. So don't keep quiet. Share the benefit of patent system in school, colleges, universities, and even in the public or in society also. Utilize the resource through organized R&D activities. Capture the global market judicially. Earn the profit through the protected market only. Otherwise, somebody may copy your technology and they become the competitor of you. Therefore, keep in mind that get protection with all the IPs, then come in the market. Thank you. For any questions, now you can have a discussion of 5 minutes.
Yes, thank you, sir. Hanji, yes, students, please, if there is any query, please ask me a question. You can unmute yourself and ask the question, or otherwise you can put the query in the chat box.
Yeah, I have given feedback link in the chat box. Please fill that. Those who have filled, they only getting the certificate. Otherwise, you will not get the certificate. Then don't say anything to me or your coordinator.
Yes, sir. Yes, students, link is already shared with you through the chat. Please fill that feedback form to get the certificates. And if there is any query, please ask the questions. Yes, Krishna Murthy. Yes, please. Krishna Murari. Yes, please hand.
Now participant can unmute themselves to ask question to our respected resource person of today's workshop. They are allowed to unmute themselves. Please unmute yourself and ask question, please.
Krishna Murari, you can ask question directly. Unmute yourself. You can ask. If unable to ask, then you can put in the chat box. Somebody will read for me.
Sir, a very simple question from my side.
Yes, sir.
Can you share 2-3 examples from field of education regarding the patent and copyright, sir?
In education department, what is your subject? If you are writing new books, articles,
Yes,
that's for the copyright. It never comes under the patent. If your method of presentation of your work is also not comes under the patent.
okay, sir. For example,
Yeah,
in our teacher training colleges, we are preparing teaching aids, different
yes,
kind of teaching aids in different
that is a
subjects.
device. If that is device, then that is an subject matter of design. You would simply a pattern of putting the how you are teaching. That's an copyright matter, not under the patent.
Okay,
For
fine.
the patent, as I told you, idea is patentable, but idea should be in the form of product or process. Same in the teaching field, idea can be in the form of book, poem, literature, something that comes under the copyright. But idea, which is form of product or process, comes under the patent, and that's a patentable subject matter in India.
Sir, for example, you have given a simple example, like one teacher have one idea to prepare one three-dimensional model. That
Yes.
model will be a particular teaching aid to show in different schools. That can come under the product, I think.
Yes, but what is the technology in that? What that's again questionable. If it's something device product, for example, fridge, TV is an product. This how it made first time cooker somebody made that got patent and design also. Some are both will come. If it is in design, it can come under patent and design also.
Okay.
Milton come under the trademark, trade name.
Fine,
So
sir.
depends on subject matter.
Thank you, sir. Thank you. Madam Krishna Murari can ask a question. I think she has raised a hand.
Yes, sir. Yes, sir. Yes.
Okay, any chat box, you can check chat box. Any question are there?
There is one.
कुछ नहीं ऐसा लिखना ਤੁਸੀਂ ਪਜ਼ਲਸ ਕੀ ਹੁੰਦੀਆਂ ਰੀਕ੍ਰੀਏਸ਼ਨ ਐਕਟੀਵਿਟੀਜ਼ ਕੀ ਹੁੰਦੀਆਂ ਉਹਦਾ मीनिंग ਲਿਖ ਲਓ ਫਿਰ ਅੱਗੇ ਉਹਦੀਆਂ ਟਾਈਪਸ ਲਿਖ ਲਓ ਪਜ਼ਲਸ ਰਿਡਲਸ ਗੇम्स ਆ ਗਏ
Any other participant, please?
मनो मैंने जो हम रिसर्च करते हैं और उसका लोगो हम कैसे क्या क्वेश्चन है प्लीज एनीवन कैन रीड दैट स्वातेंद्र सिंह संजय सर दैट क्वेश्चन प्लीज टेल मी मैंने वो रिसर्च व्हाट इज दैट मैंने वो रिसर्च करते हैं और उसका लोगो हम कैसे डिसाइड करते हैं क्या है इसका मतलब
Sir, I
यदि आप
think
रिसर्च करते हो तो प्रिंट हो गया लोगो करते हो तो ट्रेडमार्क हो गया लोगो मींस अभी तुम कंपनी स्टार्ट कर रहे हो तुम्हारे कंपनी को क्या नाम देना है कैसे लोगो रखना है वो ट्रेडमार्क में आ जाता है अभी रिसर्च की कंपनी है तो रिसर्च का ट्रेडमार्क भी दे सकते हैं ग्लेन मार्क कैसा लिखता है वो स्टाइल से लिखता है सन फार्मा कैसे लिखता है स्टाइल से लिखता है रेडी
बना लो अपनी फाइल ठीक है
वो ट्रेड नेम हो गया
चलो हो गया टाइम
प्लीज डोंट स्पीक somebody speaking not if there is no question we can proceed further sir
Yes, sir. Yes, sir. I think there is no question, sir.
okay
yes,
no
yes,
problem.
please go ahead.
Thank you so much, sir, for sharing wonderful information. I would like to express my gratitude to all the participants of the workshop for their presence and contribution to make this workshop a great success. I extend my gratitude to our honorable speaker, Dr. Bharat, to take out time from their busy schedule to grace the occasion. Thank you for inspiring and encouraging us with your valuable information on the topic, IPR and patent and design filling. Sir elaborated in detail about IPR through number of day-to-day used articles and day-to-day examples. Why it is required emphasize on this aspect also, document required to fill the form for patent grant procedure as well as suggestion to fill the patent form. So thank you so much, sir, for sharing this wonderful information with faculty and students. I, on behalf of management, principal, staff and students, extend a very hearty vote of thanks to Dr. Bharat. Thank you so much, sir. Thank you. So please stand up for the national anthem.